All right. Well, welcome to our Now What Legal Information series brought to you by the Washington County Law Library. Today, we have Javier Spyker from Hernandez and Associates joining us to talk about probate. So with that, Javier, I'm going to turn it over to you.
Thank you, Amy. I'm happy to be here. I am an attorney located in Beaverton, Oregon. Probate is one of the primary areas of focus for this law firm and for my practice. I've been practicing about 9 or 10 years now, and I really enjoy the probate process as far as helping families navigate and clean up the estates of their loved ones. What I'm going to do is describe the two processes for probate we have set out in under Oregon law, and feel free to ask any questions along the way, or hit any button or type in a question. And then I guess the last thing I would note is I enjoy this topic so much that I have an adjunct instructor at Lewis and Clark Law School, and I'm an adjunct instructor in the fall for Willamette Law School, my alma mater. So practicing and teaching in this area of law that I find interesting and rewarding. And so I'm going to attempt to share my screen, and hopefully you'll be able to see the slide and read along with me. Okay. From beginning. Okay, so that's my name and my phone number there, and the logo of my law firm, and happy to answer any questions offline if you need it, and my phone number will be at the end as well. Okay, so probate is a legal process where the court is overseeing distribution of assets left by a decedent. Assets left by the decedent are cash value, real and personal property, and these are typically assets held in the decedent's name alone. So if the decedent is co-owner on a car or a piece of property or a bank account, usually those assets will pass with some survivorship rights due to the jointly owned nature of the asset. So probate doesn't always include all of the decedent's assets. Sometimes we're going to probate just for things that were left in the decedent's name alone, and we're looking for the court's help to transfer those assets. So there are two processes for probate. There's the small estate, and then there is the full-blown probate. Small estate has a couple barriers that you need to be aware of. First is the total value of a small estate cannot exceed $275,000. So any combination of personal assets or real property assets that go above $275,000 will prevent you from being able to access the small estate process. And no more than $75,000 is allowed for personal property. So that would be bank accounts and cars and tools and jewelry and things of that nature. And then no more than $200,000 is allowed from real property. So if you own real property in Washington County, for example, you're probably going to be subject to the full probate process because there's not that many pieces of real property that fall under $200,000 mark. So that catches a lot of people off guard and puts them into the full probate process. So the small estate basics would be that you cannot file a small estate unless 30 days have passed. and that's a hard rule. And what a small estate is it's essentially an affidavit, a sworn statement to the court that you're going to do certain things to help to administer the decedent's estate. You're going to send notices, you're going to file last taxes, you're going to satisfy any creditors, and you're going to do it in the priority that the law outlines for you. So when people go to do a small estate, they are taking on a lot of responsibility, and the law sets out that they may personally be liable for mistakes, omissions, or failures to perform a duty. So the small estate process is ripe for making mistakes or transferring liability from the decedent's estate over to the person who's filing that affidavit of small estate. So it is a quicker, it is one form that you fill out and you file, and that's it. And then you are responsible. The court sets you on your own to fulfill the duties that you have sworn to that you will do inside of the small estate affidavit filing. So the court won't check up on you, but creditors may come looking for you. The tax man is always there, and it's a process that, while it's quicker in that you file one document, it does kind of have a little bit of a tail to it, in that creditors and heirs have a time frame to which they can come in and contest the small estate affidavit and ask you to refile or seek other help from the court to enforce their rights against the person filing the small estate affidavit. So in contrast to the single document filing of a small estate, the probate process is a formal process with many court filings and many steps along the way. And each step is a communication with the court, formatted in the proper way the court wants to see it, in order to get the court's permission, and the court is overseeing each step. So usually the formal probate starts with somebody filing a petition and an order for appointment of personal representative. That petition is a fairly lengthy document. It comes with a filing fee. The filing fee to start out is usually around $591, I believe, off the top of my head. And that petition sets out who the decedent is and who the heirs and devisees are, people that take gifts under the will, and sets out the basis for the court's jurisdiction, whether there is a will or there isn't a will, and also sets out some guesstimation of the value of the estate. Now, if there is a will, that will usually be filed concurrently. And if there is not a will, then we will be relying on the default statute of intestate transfer of assets. Intestacy is when somebody dies without a will. For an intestate estate, the court will usually require a bond to be filed. And a bond is simply insurance to protect the heirs and creditors of the estate. Most wills and have language in there that tends to waive the bond. So a bond will be required before the court will issue authority to the personal representative. Authority is issued to the personal representative via what we call letters of administration or letters testamentary. those letters is it's basically a one-page document signed and sealed, stamped with the court seal, and that lets third parties in the world know that you have been vested with the power by a court to carry out business on behalf of the decedent. So with letters testamentary, you can now go talk to the bank that holds assets in the decedent's name. You can begin to file taxes or deal with tax matters under the decedent's name. You can deal with creditors, and you can also hire a realtor and start getting appraisals, because all of those professionals will want to see that you have some kind of legal authorization to do what you are attempting to do now that the decedent has passed. After the petition has been filed and letters of administration have issued, within 30 days, the law requires you give notice to interested persons. Interested persons are typically creditors of the decedent, and you can issue notice in a few different ways. The most common way is via publication, where we publish a formal notice in a newspaper of record in the county where the decedent was domiciled. And that notice is published and runs for 3 or 4 weeks or publications. And that notice is posted generally within 30 days of appointment under the law. At the same time, within 30 days, it's also a legal requirement that we give notice to devisees, heirs, and other interested persons that might have been listed in the will. So directly, we are mailing out the required statutory information to devisees. Those are people who have been named gifts through a decedent's will. Heirs, natural heirs, sons and daughters, aunts and uncles, parents in some cases, are all entitled to legal notice. And then we provide that proof of notice back to the court in a filing saying to the court that here's the notice we sent, and here's who we sent it to, and we did it on this date, and we are compliant with the notice requirements. One of the entities that is given notice is the Oregon Department of Health and Human Services, or DHS, and DHS is always noticed, and DHS may have a lien, or they may act as a creditor for people who were reliant on Medicare and Medicaid systems, who racked up medical bills during their final years. And sometimes when we send notice to Department of Human Services, they then come back with a final bill for the decedent, or maybe a decedent's spouse that had predeceased. So state of Oregon is a creditor that gets in line to recover money spent on behalf of the deceased. A next step in the probate process is that we will obtain a tax ID for the estate, and we will file a final tax return for the estate and the decedent. We do that with the tax ID and with certain IRS forms where we give notice to the IRS that we are representing the decedent and the estate. And at the same time, we obtain a federal tax ID number for the estate. We use that federal tax ID number to open up a estate bank account. A bank account that is designed to hold the assets of the estate and collect the proceeds of the sale of property to be later distributed once approved by the court. So the estate account is not an account where money can be taken or withdrawn or transferred. Typically, there are many restrictions placed against the estate account and the assets of the estate. There is a legal standard by which assets in the estate account will be distributed, and there's also an accounting that will be done. So before the accounting can be done, at the end of the process, it is required that we file a formal inventory with the court, listing all of the decedent's assets and property. That inventory is usually filed within 90 days of appointment of the personal representative. And if the assets change, or if assets come into further knowledge, or say there was a bank account that was missed or a car that was missed in the first inventory, supplemental or amended inventories will be filed with the court, and the court will track those inventories and track the assets within those inventories to make sure they get to the right persons. After the inventory is filed, there's also notice to claimants and an affidavit of compliance regarding the claimants. So claimants are anybody who is owed money, and the court will want to see that those debtors or claimants or creditors, we use all three terms interchangeably, those creditors have been satisfied or have been given fair notice under the law. And so after we give notice to the creditors, we also file an affidavit of compliance, a sworn statement saying to the court that I have notified the creditors and I have reviewed the mail and I have looked through the decedent's stuff and taken all the appropriate steps to identify anybody who's owed money. So those notices and affidavits start time periods of which the claimants, the creditors, have to come back and say, yes, I have a claim. So one of the most common claimants is maybe a final ambulance bill or a final medical bill that the decedent had racked up during their lifetime. And so the ambulance company will will have their final bill. We'll send them notice that they need to submit, make a formal claim against the estate, or if we consider the bill valid, we will just pay it. But those creditors will be dealt with, and after a certain amount of time, a certain period of days, creditors become barred from claiming against the estate. So it's beneficial to notice the claimants and get that clock rolling against them. So if they miss the time period to claim, then you can potentially disallow the claim. So after four months after delivering notice to the heirs, statutorily they are barred from bringing a will contest. So people say, why does probate take so long? It's because there are these 30 days and 4-month waiting periods built into the process to give everybody a chance to make a claim or protect the heirs' rights to receiving property. So we file something, and that usually starts the clock or a timer, and then we wait out the time, and then at the end of that time period, we do the next step. One of the things that holds probate up or keeps probate open is decedent's final tax returns or doing a final process on the taxes. Some people tend to stop paying taxes towards the end of their life and stop filing, and then we have to go back and figure out all the years they haven't filed and file a bunch of catch-up filings. If the estate is over $1 million in assets, there will be a Oregon tax return due, a death tax return due, and that tax return is usually due 9 months after date of death. If the estate cannot close, cannot be finalized within a year, then the court requires we file an annual accounting to the court all of the assets and expenditures of the estate. And that's a pretty involved accounting down to the penny. So every penny in, every penny out would be accounted for. All bank statements would be provided. All receipts will be provided. All expenditures will be accounted for and questioned by either heirs, creditors, or the court. And if we can close the estate within a year, we will file what's called a final accounting, and we will ask the court to close the estate and approve distribution after taxes, creditors, and expenses of administration have been paid. The heirs will then receive the proceeds of the final accounting and petition for general judgment of distribution. Distribution does not wrap up the estate. Usually the court will want to see receipts have been filed and submitted. So the heirs the court will want to see proof that the heirs have received their property, and in the form of a receipt. And after the receipts are filed, then there will be another filing in the form of a supplemental judgment asking the court to release the bond, release the personal representative from their duties, and close the estate. So that's the formal process. It's obviously very involved and lengthy. And if anybody has any questions, I'm happy to dive in deeper. So the reason we end up opening probate is usually because we need title to the land, or we need access to stocks and bonds or large bank accounts. We also open probate so we can have the court's power to collect debts that were owed to the decedent. We open probate sometimes to settle disputes between people who claim they're entitled to assets. So, multiple marriages, extended family, people coming out of the woodwork to make a claim against some of the assets, kind of the stuff that movies are made of. And also, we can use the probate court to settle the validity of a person's will and that person's intent to make a will. So usually when people come into my office, it's because they're trying to clean up the estate. They're trying to either sell or retitle the land. Once the decedent is gone, nobody is there to sign that title and create a clear chain of title. So we're always opening probate based on managing the real estate. And there are probate avoidance measures. Everybody passes away, but not everybody's subject to probate. Avoiding probate, some people start distributing assets before they pass away. They start gifting and giving and getting things out of their name because they know they're not going to be around very often. That's not the tax preferred method of distributing assets. More advanced estate planning will rely on trusts and trustees to grant the authority beyond somebody's lifetime to manage assets. And there are many types of trusts: family trust, joint trusts, generation skipping trusts, all kinds of tax advantaged living trusts. So those are more of the sophisticated products we use to avoid probate. I'm typically having consultations with families, and they may have dealt with their parents' estate or a family member's estate, and they realize the burden that probate is, and they're looking to avoid it. But some families with lots of complexity and lots of issues depend on the probate process. So there's a court and a referee there, somebody watching the state of the assets and make sure they go where they need to go. And that's all I really have prepared for remarks. The next slide will give you my phone number, and I would open it up to any questions that the attendees may have. And I think I see a question come in from the comment section, and I will address that question. The question is probate open in the state of the dead person or the people who are inheriting? The answer is that probate jurisdiction is granted where the decedent is domiciled or holds property. So if the decedent lived and died in Washington County, that's generally where we're going to open probate. If the decedent lived and died in Washington County and held property here, we're going to open property here. But if the decedent also had a condo in Hawaii, we're going to have to open a auxiliary probate, secondary probate in the jurisdiction of Hawaii in order to probate that condo asset. So where property is located or where the decedent was domiciled is where we will be opening probate. The persons who are inheriting do not create jurisdiction, and they do not have a jurisdictional right to open a probate in Colorado when the decedent lived in Oregon. So I hope that answers your question. I think if anybody has any other questions, we have reserved an additional 30 minutes. But let me see if I can turn off the screen share. All right. Oh, okay, I'm back. So if anybody has any questions, we're happy to answer them. At this point, you're also welcome to visit the Washington County Law Library. They have a great amount of resources there for you as far as books that lawyers rely on, and maybe some of the forms are available. The Washington County Law Library is a great resource to people both in Washington County and in the metro area. It's located in the juvenile building across from the courthouse on First Street, and they have very good primary sources and enough information where people can access for self-help. The probate process is meant to be accessible and open for the public, but because of the many regulatory and legal filings, most families find it difficult to navigate and end up needing the advice and help of an attorney. And if anybody has any questions, we're also happy to answer those. And we'll hold it open for maybe another 5 or 10 minutes. And
I am not seeing any more questions, but I did want to share that we do have other sessions coming up. So thank you very much, Javier, and we'll keep this open for people to see. But we do have next month, let me pull this up. Next month, we do have Anne Marie Clark coming in and talking about family law. And then in June, we will have Rick Peel talking from the Oregon Law Center talking about something else. If you have any questions for Javier, please type them up or raise your hand and we can answer those. Otherwise, thank you so much for joining us this evening.
Thanks, Amy. It was good working with you on this project. Most people don't have any encounters with a lawyer until the probate process at the end of their lives. And so there's a lot of questions and concerns about working with a lawyer and how that all works. My office focuses on helping families navigate, these probate issues and recover assets of their loved ones. So it's rewarding in that way.